So I suppose by way of introduction to myself, I started life as a civil engineer. I then did an honours degree in economics, and then I did my qualification in law at the University of Melbourne. So I progressively specialised in this area where engineering, economics and the law interact. And today we're dealing with defects in quality, which is an important sort of area where those three things come together, and the law and the industry have had to work out some successful and unsuccessful ways of dealing with defects. So I suppose that we start off with a bit of a purpose for the seminar, and it's to discuss the defect risk management. How do we organise defects? What are they? How do they operate? What are the principles that govern it? How do we work through the meshing of statutory law, contract law, case law, and practical strategic advice to make something of a good festive project? The other thing to remember, I think, about defects is that they're inevitable. You won't get a project that never has a single defect. So you're going to have to deal with them really whether you like it or not. The other aspect to remember about defects is they have a great propensity to create waste. So a defect that between reasonable men could be forgotten, and reasonable people would say, oh, that's all right, that's close enough, that looks good, I'll accept it, can go away for nothing. If you get two unreasonable men, two unreasonable persons, one who says, look, I want that until it's absolutely perfect, and the other person who says, well, I'm not going to fix anything that I don't need to. So there's a loggerhead. That loggerhead eventually will follow down through the layers of defect and dispute resolution until it ends up costing someone a lot of money. A lot of money on site, a lot of money in costs and professional expenses after that. So what we want to deal with is to understand what constitutes a defect and what legal implications it has, to identify the statutory and contractual frameworks. We'll look particularly at where the courts have landed on various cases, because we want to get a feeling of how a dispute about defects is going to look towards a judge if it ends up on his in his court. And we've got to develop some strategies for dealing with defects and resolving them, minimising them, reducing them, and perhaps accepting them. And the situation is seeing this build together as an intelligent attitude to the management of construction contracts. So if you look at what is a defect is when work's performed but fails to meet the standard expected. And that could be under the contract, it could be under statute, regulations might prescribe something, or it might even be a failure to build something with reasonable care, which might arise under a common law duty. If we look at examples, we can have poor workmanship leading to water ingress, a very favourite defect in many quarters at the moment. You might have structural failures due to inadequate reinforcement. So again, the situation is that you've got a major problem. Installation of products that are not compliant with various rules, industry codes and statutory requirements. And then you get down to the incorrect finishes or improper detailing. And it might even be something that leads to a long-term maintenance issue. So if you've applied the wrong sort of epoxy to a concrete surface and that will cut out, its design life is 10 years, not 15 years as specified, what do you do with that defect? We'll look to see if we can resolve some of those and identify the principles that will apply to get them resolved. The characteristics of it, looking at the classification of defects now, and we'll send a copy of these slides to you, of course, after the conference. But there's some important definitions and concepts that are applied to defects when we speak about them in the industry. One is a patent defects. That's obvious on reasonable inspection. And it's typically raised shortly or after you do a practical completion inspection. And examples are misaligned windows, cracked finishes, visible leaks, things that are obviously not in accordance with requirements. They're important because oftentimes one's asked to sign a release on the basis that you release patent defects, and therefore you should be careful that you've got an idea of what are the patent or obvious defects and what are you giving up if you sign that release. Contrasted to patent defects is latent defects, things that are hidden or not able to be found by inspection. And that might be lack of reinforcement in a slab. It might mean corrosion or internal cracking so that you can't see it then. So typically one doesn't release latent defects on the resolution of a defect dispute, not identifying them. And latent defects often involve more complex investigation, expert reports, sometimes x-raying concrete slabs, etc. Concealed defects have the idea that perhaps they may be hidden behind finishes or within structures, or they arise from defects in design or workmanship were not apparent at the time of installation. They also carry a concern that perhaps they're covered up defects, that is, a contractor or a subcontractor has actually covered up defects. One recent example I came across that was the idea of somebody having discovered mould in a property but not having the situation of addressing it. He just sort of put the wall back over the mould and left it to somebody else to deal with. So that's also an aspect that you should be aware of. The other aspect is it matters according to various avenues of recovery as to which of these defects one has released, either impliedly under the contract or expressly under a settlement deed of some description, or what transpires from that. The other classification that's important here is incomplete work, which is different from defects. A defective work is traditionally work that has been done but is not satisfactory, whereas incomplete work is work that has been not done. And that makes a bit of a difference because, as we'll see, if you sign off on a final certificate or a certificate of practical completion, you may, depending on the terms of the contract and the arrangement struck at that time, you may actually be releasing incomplete work. If you say to a contractor, well, look, that's okay, you've finished your job, I'm happy with it, you can go home, then perhaps you can't come back in a year's time and say, well, hang on, these bricks were missing, or you didn't do the architrave properly, or you should have put an extra attachment on the roof for convenience. So you've got to be careful that you're not mixing up various aspects of defects in an unstructured way. The other aspect is to look at defects from another classification, that is where they're coming from. For instance, contractual standards, that is what you have contracted to do. So you'll have drawings, specification, performance benchmark, quality standards. You might have expressed terms saying this will be done in this particular way. Also, you might have implied terms requiring, say, reasonable care and skill in the performance of the work, which 2 years later, somebody might say you haven't displayed. So contractual obligations are important. Statutory obligation, the National Construction Code, Building Code of Australia, deemed to satisfy, and performance-based standards are all relevant to see whether or not there's a defect. So, for instance, if you've got a situation where somebody claims a defect because you haven't satisfied a particular code standard, it may be possible to justify that by way of a performance-based standard, by having an appropriate professional certify that the work that has been done is satisfactory and therefore does comply with the code. Again, you've got to be careful, say in the New South Wales and other jurisdictions, that you've got to comply with planning and building approvals. And that is, you've got to be careful to make sure that the work that you're doing is in compliance with the with the approvals which have been given. You've got to resist the temptation, as a friend of mine often gave way to, of putting in an extra wine cellar at the bottom of various houses and not necessarily checking out whether the council approved it. It's not kosher and it doesn't satisfy those requirements. The other aspect with the Home Building Act, for instance, in New South Wales and practically every other jurisdiction, statutory warranties apply to residential works. And again, you've got to be careful to make sure you comply with that. You've got as a basic set of standards the common law, which will usually imply, unless it's excluded, a duty to exercise reasonable skill and care and to warn of defective designs or construction practices, particularly where the risk is foreseeable and the party is vulnerable. So the common law with duty to reasonable care was all the protection we had apart from our contracts some years ago, but now with the statutory regimes coming in, there's improved protection, but still the common law has a role to play in controlling the quality. You'll have a situation where the contract standards do provide for a wide range of responsibilities with a quick clause. So you might have a contractor must carry out and complete the work in accordance with the contract documents and in a proper and workmanlike manner. So in a simple question, a simple clause like that might impose a lot of obligations for a lot of responsibilities in respect of every aspect of the work that's being undertaken. And again, the situation of merchantable materials used must be new, suitable for their purpose and of merchantable quality, imposes on the builder a responsibility to make sure that the materials he actually uses are up to standard. And even if the supplier hasn't performed his job, the builder is still on the hook if in fact the materials used are poor quality. And again, you might have a contractual clause that says the contractor must comply with all applicable laws, including the Building Code of Australia. And again, you might get some fairly onerous responsibilities coming through fairly simple clauses. And it's important to watch your contract to make sure that the standards it imposes are going to be those that you've undertaken to satisfy. We then come to this case of Belgrove and Eldridge in 1954. It's a High Court case, and it's where the builder constructed footings that was structurally unsound and non-compliant with specifications. And there the court was faced with a situation, well, what is the extent of damages for which the builder is responsible? And the holding that was achieved there was that the proper measure of damages was the cost of demolishing and rebuilding in accordance with the contract. So there it's pretty tough, old common law principle. If you've promised to provide a house of a certain standard, i.e. structurally sound, and you didn't provide it, you'd have to rebuild the whole lot at a great cost. And the situation is there that the court said, in the present case, the respondent was entitled to have a building erected upon her land in accordance with the contract and the plans and specifications which form part of it, and her damage is a loss which he had sustained by the failure of the appellant to perform his obligation to her. So the situation is that perfect performance in accordance with the contract was the classical test for Belgrove and Eldridge. And that's still good law today, and it's cases which follow it and apply it and put a gloss or an application on it that gives us further guidance. The other aspect you've got to look at in terms of the administration of contract is the role of the superintendent in defect management, because the superintendent in the traditional sort of principal contractor superintendent contract, AS2 1 to 4, etc., and that family, inspects the work, issues instructions and directions to rectify, determines whether you've practically completed work, and certifies the completion of any rectification works. It has a role to play that's important. the terms that govern the role he plays are covered by the contract and are worthy of close attention. On the one hand, you can have a superintendent who's required to introduce a management to the project which is independent and must act fairly and reasonably. But more modern contracts have often said he's not an umpire, he's the agent of the principal, and therefore he has little or no responsibility to be fair and reasonable and have regard to the contractor's interest. A contractor looking at the job and the risks involved often should look at the superintendent clause and what that means. Now, the situation is that usually there will be in the contract a power for the superintendent to give a reasonable time to comply with the contract, and a failure by the contractor allows the principal to engage others and recover costs. And the superintendent's making a lot of practical decisions in that respect and should be importantly connected and reported to and required to carry out his inspections in order that both parties have the protection contemplated by the contract. The other aspect about defects is the defects liability period. This is a period commencing at practical completion, during which the contractor is obliged to rectify any defects which are identified by the superintendent or the principal. The situation is usually 6 or 12 months, and the contractor usually is bound to return to site and rectify the cost, or the principal engages others. It's important to realise, although that period operates as effectively a period during which the contractor must jump to his rectification quickly, it isn't the end of liability for defects. So it's important to see, yes, the defects should be corrected at the time, but they don't give a full release to the contractor. Again, with a final certificate, it's issued at the end of the defects liability period and certifies all works are complete, all notified defects have been rectified, and a final payment is made. So it usually operates the acknowledgement of the completion of obligations. And presumably it could be argued as completion of obligations for patent defects, for defects which have been obvious on inspection and you've signed a final certificate as a superintendent principal. You'd expect that that would resolve the question of completion of the works. But it might not and would not usually override liability for defects or statutory warranties. So again, one's got to be clear at the time one gets a final certificate as exactly what's got. The other aspect is looking at some cases. East Ham Corporation and Bernard Sunley, the case will be in the papers delivered to you, was completing roofing works for, the contractor was completing roofing works for East Ham Corporation. Years later, latent defects were discovered after a final certificate had been issued, and did the issue of the final certificate bar the employer for pursuing claims for latent defects? And it was held it was conclusive only to work apparent at the time. It didn't prevent the employer from later claiming for latent defects which are not reasonably discoverable. So it's important that the court had a difference between patent defects on which parties could understand their rights and latent defects where they couldn't be expected to have signed them off. Another aspect that comes into the consideration of defects is that the limitation periods are important. Now, usually for contract, it's 6 years from the breach of the contract. So if somebody hasn't put reinforcement into concrete, then 6 years after that breach has occurred, the opportunity to sue him under the contract is lost. Tort is usually 6 years, but from when the damage occurred or was reasonably discoverable. So that's a more complex time limitation, but fundamentally, once 6 years after the problems occurred, you're on notice to get your claims in quickly. Statutory warranties, 6 years for major, 2 years for minor. defects, so one must be quick to notify them lest one lose the benefit of the claim. Fundamentally, if you claim outside that time limit, it won't go anywhere. Misleading conduct, which is under the consumer protection, 6 years from damages. The exception of the rules recently been introduced by the Design and Building Practitioners Act in New South Wales, where the statute of limitation is 10 years and 10 years going backwards. So you've got to be on your mark there. So it's important to understand those situations. The other aspect that comes out of the case we've been looking at is that the cost of rectifying the works to conform with the contract is the primary measure of your loss. However, there's an exception or a rider to that principle, that if the rectification is reasonable, that is excessive or it's costly without any benefit to anyone and wasteful, then the court may award the lesser amount of the diminution in value. So that, say for instance, somebody says, well, you built the house, but you built it with the wrong coloured bricks. Instead of dusty pink that I ordered, you've given me rosy pink. So they say, well, the whole house has got to be pulled down, the bricks have got to be pulled out of it, and you've got to give me the bricks I asked. If one went to court, one could make a strong argument that the diminution in value between the two pinks was pretty marginal, perhaps 20 grand all up, whereas the cost of rebuilding the house might be $1 million. So that's an important exception, important qualification to the usual measure of complete rebuilds. The aspect of a minor issue, colour of bricks, it might be a provision where the wall has been put in, 100 millimetres short of where it should be, and the house is accordingly smaller. Perhaps one wouldn't pull it down to do it again. So it's an important principle that you've got two measures. Usually rectification cost will apply, but unless it's unnecessary or not reasonable to do it. So it's important to keep those two principles in mind when we look at the other cases. So if we give a summary, defects must be assessed against contractual, statutory and common law benchmarks. Rectification damages apply unless the cost is unreasonable or unnecessary. And latent defects are usually not discharged by final certificates. So when we look at the case law, we've got to look at how the cases have evolved, the law in relation to a particular topic over time. The attitude of the courts back in 100 years ago is different from the attitudes today. And whereas in other times it might have been a situation of looking for the oldest authority that was the ruling authority that applied. Nowadays one looks to the modern judges and their recent judgments to find out the current feeling of the profession. So one other aspect about this is to recall that in a contract you can often have a strict liability to do something. So in a case of independent broadcasting authority and EMI electronics, the EMI undertook to do a transmission mask, and they designed it, but it collapsed due to some complex wind loads that were exposed to the transmission mask. And the situation is that it was held that if it had been the duty of the contractor only to use reasonable care, then he might have used reasonable care. But in fact, his contract said that he had to provide something that was fit for that purpose. So he'd taken on a strict liability to actually meet the demands of that application, not simply as an architect would, which is to simply keep the reasonable care and adopt the reasonable precautions that another reasonable architect might adopt. This contractor had signed up to a fitness for purpose term. So it's important, again, in your looking at a contract and its responsibilities, to make sure that you understand whether there's a strict liability or a duty of care. The other aspect that one has to realise is that one has a different measure of damages in contract or in tort. In tort, the duty of care is basically to recover the damage that's been suffered. So if there's a failure of the duty of care, you constructed a negligent structure, then the usual sort of damage suffered by that is the cost of constructing an appropriate structure. So if you put up a dodgy wall, then the damages are the cost of putting up a proper wall. But in contract, you can have larger damages. The damage in a contract is what was either naturally arising out of the breach or which the parties contemplated would arise out of a breach. So the leading case is a case long ago, Hadley and Baxendale in 1854, and there Hadley, a mill owner, had contracted with Baxendale to take a broken crankshaft to a manufacturer for replacement and get it back fast. Due to Baxendale's fault, the crankshaft was delivered late, and it resulted in Hadley losing profits during the downtime of the mill. The central question was whether or not the lost profits due to delay in delivery, amounting to £300, was recoverable as damages. The court said, well, he wasn't advised of the specific circumstance that would lead to such losses. So they said, no, it's limited to those that naturally arise from the breach, which was the direct costs of the delayed delivery. It wasn't the loss of profits. So these two limbs mean that losses in contracts can be much greater than a loss in tort in certain circumstances. And if you consider defects, say, for instance, you have a loss of profits from defects. For instance, a structure is constructed, it's finished, but then it's understood that there are defects in it which prevent its operation. Well, then the circumstances might be, well, yes, it's got to be out of use for 6 months while it's being rectified, but the loss of profits during that 6 months might be extreme. If you're talking about a hotel or something that's an expensive infrastructure project, the losses can be excessive. So it's important to realise the contracts and their effect on the losses that come from defects has to be carefully reviewed. The other cases where the courts have come down to look at damages on defects, a few cases that we can look at to see which way the courts are going to jump if you have a defect claim. In the case of Galambos and McIntyre, there the report was said not to be a reasonable method of dealing with the situation because it was out of nature, and therefore they awarded diminution in value. The other one that's useful to remember is Cassidy versus Ingwerda Construction Company. That was a 1968 Queensland case where, depending on the terms of the contract, it was necessary to give notice to a subcontractor in that case in order to recover damages for defects. So it wasn't appropriate that you could go and just fix up the defects and give him the bill. Depending on the contractual provisions, it was necessary to give him notice and opportunity to fix them. The takeaway from Ingwerda's case was that it's well useful and necessary that a contractor fix his own defects if it's at all possible. The reason for that is his costs of fixing his own defects are likely to be a great deal less than that of a new contractor. An existing contractor is confident of the work generally that he's done and only needs to fix the defects. A new contractor coming in may well take the view that all of the work should be removed and it be restored completely, and the cost involved is much less, much more. Additionally, the situation for a contractor may be that he can go to his subcontractor and expect the subcontractor to fix the defect, or at least be a part of the costs. So one of the issues that's important when looking at defects is to see the extent to which the contractor can complete them. Again, another case of Burke and Lunn, 1976 in the Victorian Supreme Court. The house was built with defective footings, causing extensive cracking and structural instability. The Burke sued for the full costs of rectification, and the diminution in value was argued, but the court said no, it's a full cost. And the situation is therefore is both reasonable and necessary in this case, and so fundamentally defective that it had to be fixed, and the full cost of full rectification was ordered. You'll understand as well that the principle is that the damages of the cost of full rebuild is the award that's given by the court. But there's no requirement on the person who gets that award, usually, to spend it on rectification. And it does present a bit of a moral hazard in the sense that if you have a defect that, for instance, causes you to be able to argue for a full rectification, that you might get the full rectification cost and be content to invest that in your super while enjoying the property that you had without rectification. So there's a temptation for a principal to seek to get an undeserved sort of measure of damages in order to get more than an appropriate recovery. The situation is that, again, a Viking grain storage case and White Installations Limited in 1986, the defendant designed and constructed grain drying and storage installation, which was failed to be fit for the purpose of drying and storing. The court implied a term that the completed works must be fit for purpose, and held that that term was breached, and the circumstances they were liable for both design and construction. So the idea that as to what extent you take on the design responsibility for structures is very important when you come to look at defects later. Another case of a Coscott and Fewings Joinery Proprietary Limited, the homeowners endured significant inconvenience and stress due to joinery defects and delay. And there the court awarded general damages for inconvenience and disruption. So the situation is not only is the damage limited to the cost of the defects, but if you have in modern day nervous stress and inconvenience, you may also get damages on top. So it's important to realise that damages are looked at generally and not limited to the cost of rectification. A leading case of Bryan and Maloney was a case where a homeowner, being the second owner of the home, had suffered loss from latent foundation defects. He bought a home and he didn't have any contract with the builder, and his contract with the owner didn't protect him as to the quality of the building. So the question is, when he sued the builder, the second homeowner sued the builder and said, well, you owed me a duty of care because you knew that I'd be relying on the quality of your construction, and therefore you should have taken the necessary care to make sure that I didn't have these foundation defects. And there the court held that he was entitled to recover. The builder did owe a duty of care to that subsequent purchaser. Now, that case is regarded a bit as a high watermark and is principally limited to residential developments and situations of express reliance on the quality of the builder, but it shows where the courts will go to if the facts of the circumstance justify this particular application. Another case of Rotterdam and Frank Haslam Milan, 1996, is a case where the contractor used in the construction of a concrete floor slab steel slag. So the rubbish from a steel mill was used as part of the aggregate that was put in under the concrete floor slab. The situation is that the specification required granular hard core to be graded to uncrushed gravel, stone, rockfill, crushed concrete or slag, or natural sand, or a combination of these materials. So the specification is a bit wide, and the circumstance that the court found that the council who contracted for this floor slab be laid didn't rely on the contractor's skill in selecting the fill, didn't rely on its own architect. It relied on its own architect in doing that selection. Therefore, there was no fitness for purpose implied. However, a term as to merchantable quality of the granular hardcore was implied, and merchantable quality must be suitable for at least one of the purposes for which the materials are commonly supplied. And there, the slag was suitable for use in bituminous macadam, but not under a concrete slab. So it was suitable for one purpose, merchantable quality for one purpose, but not for this. And therefore, the contractor was found liable for the damage. So it's an aspect where you have to be careful to make sure that the materials you're using are going to be suitable for the applications that are used for them. Another example is in 2004, Woolcock Street Investments. And there's a commercial building suffered structural issues due to defective design. There's no contract between the owner and the engineer. So the owner had bought the building after the building was done. It was held there was no duty of care by the engineer. An economic loss claim failed. The reasoning there was that the courts are reluctant to extend the boundaries of liability too wide, and they held that the plaintiff, the owner, was not vulnerable. He had the opportunity to protect himself when he bought the building. He could have said to the vendor, well, I want you to make sure that this building is satisfactory, and if it isn't, I want to recover. So they limited the application to Bryan and Maloney to exclude commercial settings, to limited Bryan Maloney to residential settings, and they held that the plaintiff should have looked after himself in that respect and not relied on suing the engineer later. The interesting case of this New South Wales Supreme Court in Westport Management Chocolate Factory Apartments, and there the defects included non-compliant mechanical ventilation, hollow core doors instead of solid skirting, boards installed incorrectly, and defects identified after the apartments were sold. So again, the apartments were sold. There was no loss to the original person, but the apartments were sold. It was held that the developer couldn't claim damages for the rectification because the apartments were sold without request for rectification. There was no proven diminution in value. So the situation is that the court refused to award damages where there was no real evidence of loss. The person who had the apartments built had sold them on at a profit, and the situation is that there was no evidence of efforts to rectify or seek rectification. So that's a case demonstrating that the courts will limit recovery if the situation warrants it. Again, another case where the courts are required to apply these principles in all sorts of tricky situations is Barton and Stiff, which is Victorian Supreme Court in 2006. The house was required to be fit for occupation. The house suffered from defective footings due to clay bricks reacting with salty groundwater. So there was a defect and there was a problem. The situation was held that the statutory warranties didn't require the builder to guard against highly unusual site conditions. So he wasn't liable for defects caused by unusually salty groundwater not disclosed to him. So again, the courts were having some limitation on the extent to which a builder or a constructor can be held liable for all bad things that happen to a building. So it's important to make sure that you specify in your contracts as a contractor exactly what sort of site conditions you're designing for and what ones would be outside your responsibility. Then we have a case in 2009 of Wiltshire and Westcourt, WASCA, where Westcourt used limestone of an inferior quality. The damages were originally awarded on at first instance. The first judge had heard it said, well, no, I'll only award you damages for surface cleaning. So I only award you to clean up the limestone and it should be all right. But on appeal, the court applied Belgrove principles, the case in 1954, which is the leading case in the area, and ordered full replacement of the limestone awarded, some $257,000, and said that the owner was entitled to restoration to the principal as if the contract had been properly performed. So the situation is that this is the opportunity where if, as a homeowner in this case, well, she could sort of decide, well, the limestone's not so bad, I'll live here with the limestone as it is and I'll pocket the $257,000. So it does raise a moral hazard of an opportunity being taken advantage of. The other aspect was, and demonstrates the principle that Tabcourt Holdings versus Bowen Investments, 2009, the High Court of Australia. Tabcourt leased some commercial premises from Bowen, and the clause included a clause prohibiting substantial alterations without the landlord's written consent. The tenant, Tabcourt, demolished and completed a high-spec foyer without consent and despite express written refusal. So he'd asked to smarten up the lobby and he'd been refused and he went ahead and did it. At the end of the lease, the landlord sued for breach of the lease and sought the cost of reinstating the original foyer and what was the appropriate measure of damages. And again, they held that Belgrove and Eldridge damages should put the innocent party in the position of as if the contract had been properly performed, and therefore they awarded the full rectification cost, saying that landlord was contractually entitled to the preservation of the premises without alteration, not consented to, and the loss of the cost of restoring the premises to the condition in which they would have been if the obligation had not been breached. So again, some fairly significant impact from those two principles. Another case of Stone and Chapel in 2017 in the South Australian Supreme Court, and there was a ceiling constructed 4 centimetres lower than contractually acquired. So rectification would require major demolition and you'd have to raise the ceiling and do it. But it was held that rectification was unreasonable and the court awarded damages for loss of amenity of $30,000. So again, it's a case where on the facts, as they're proved and presented properly, the contractor got out of that liability for a sum of $30,000, whereas perhaps to reconstruct the whole building and raise it by 4 centimetres would have cost him very much more. So it's important, if you're a contractor faced with a defect claim, that you look to where the diminution in value is a better measure, and you have to collect your arguments to do that. So trying to summarise those principles that to ensure that we've got a bit of a grip on defects and the way the court will resolve them is you've got perhaps special cases of Brian Maloney in the residential area, and you've got the legislation in the residential area which covers a lot of risk. And then you've got in the commercial area where there might be no duty of care unless you've got an express undertaking, a direct duty owed by the person involved. So if you're buying a building and it's 5 years old, then if you want to sue the building constructor for that, one would need to have an express warranty from him that the building was constructed appropriately. On the other hand, one has to be careful as a contractor to sign up to any indemnities of the owner of a commercial building or his financier or his assignee, in order that one doesn't attract a liability for all subsequent owners. So you've got to watch what sort of area you're going to be in and what sort of risks involved. So the issue is for a contractor then is to plan out the quality that you'll impose on your project, to watch for the obvious sorts of problems that one might enter into. Wet trades and waterproofing are classic examples of high-risk areas which must be watched carefully. So again, training supervisors, training subcontractors, and all the QA that you can devote to it is important. The other aspect is to document things. The situation these days is one can easily do a site report, one can easily take photographic records, and it is a benefit in the case of waterproofing or in the case of proving that you put the appropriate reinforcements into concrete, that photographic records on one's smartphone are taken regularly and frequently during the process in order to bring it together. And the situation is that if push comes to shove and you have to resolve it in litigation, that evidence is very important. So the other aspect is to make sure that if you have a defect that is spotted, that needs to be addressed, that you review the contract definition of what was your responsibility and what was others, and the defect procedures of rectification that are sensibly agreed. There's no point in going overboard on rectification if it's not necessary. And again, to conduct site inspection and photographic documentation of the defect and how it works. And then to fix it, if you can, as quickly as you can. The more that defects are resolved at the coalface, the better for everyone generally. And the circumstance is that if it's minor, sometimes it's better to fix it than argue about it. I remember in one case which had gone on for many years, I went to do a site inspection, and the major metropolitan authority that was the plaintiff showed us, after a great deal of pushing and shoving, his officers, which were supposed to be in grave danger, and the extent of the defect that was complained of in that office was effectively fixed by some green tape placed around the windows. That is, it should have been fixed quickly at the time, and it had been allowed to be included in a legal matter that went for years and caused everyone much more harm than benefit. The other aspect that needs to be looked at is making sure that the defect rectification is documented and fixed up before the final certificate, that you've got a clearance from whoever's responsible for identifying the defect, that the defect has been rectified and it's resolved, and that the retention release and the final certificate is issued, so that as a contractor you can hopefully put that project to bed and say that you've finished your responsibilities. The common pitfalls are poor training of subcontractors. That is, one hires a subcontractor mainly on some of his experience, but you always have to take someone you haven't worked with before, and unless you induct him into the way that you want things done, then you often end up with poor site supervision of his trades and inconsistent workmanship all over the place. And again, the situation is you can find that there's lots of pressures on site and lots of people are wanting to get things finished quickly, and a lot of people are wanting to rush things through, and inevitably that might come back to visit. So it's important that you train people properly, you employ them properly, they do the work properly, and you get out of otherwise ruinous claims. So the situation is that when they do arise, one should investigate the defects very quickly. It's very important to identify that it is a defect, that it is causing a problem where there's a real issue, and that the rectification of it is sensibly agreed and sensibly resolved, documented, carried out properly and resolved. Otherwise, you can find that the defect resurfaces in many years with people having different views of the rectification procedure, of having different views of whether or not it's achieved a proper result, and the problem becomes bigger than what it was to start off with. The other aspect is that you should have some idea when you start a job as to how you're going to resolve defects as they occur. One of them is you should be having discussions about the defects quickly as soon as they're identified, so you can go and investigate it before it gets exaggerated by people that aren't on site and aren't in touch with the real information. And maybe you should get an engineer, an architect, or an expert to come in and determine, how much of it is defective, what is a reasonable rectification method, in order that you can get it resolved and a common approach taken to it, and the matter finished before it goes further. If it needs more serious discussion and there's more issues with it, then one should have perhaps consider mediation or an expert determination. An expert determination of most dispute issues of defects is an efficient way of resolving them and should be used unless there's some real reasons not to. That's the area that I wanted to cover today. I wanted to take you through some of the concepts relevant to defects, and then to take you through some of the cases that have demonstrated how the courts have grappled with them and the different sorts of answers that have come up to different situations. The situation is, and these problems will present themselves from time to time, and usually in one way or other in most contracts, and one must be on his mettle to address them properly, understand the concepts behind them, and apply them sensibly in light of your contract and the other obligations associated with the construction.